Welcome back to This Week in Immigration, our conversation on the stories that matter in immigration policy. I'm Hunter Hallman.
And I'm Jordan Lapierre. This week on the program, do undocumented immigrants pay taxes? How are states responding to local sanctuary city laws? And unpacking a major decision on immigration law from the Supreme Court.
We're welcoming the immigration team back today. Teresa Cardinal-Brown, Director of Immigration and Cross-Border Policy, and policy analyst Chris Ramon, who will join us momentarily.
But before we start, remember, you can subscribe to this podcast and all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. You can also stream on our website at bipartisanpolicy.org. And while you're there, you can find more information about all the topics we discuss. Just go to bipartisanpolicy.org/immigration. Hunter, let's start with you today, actually. You wrote a blog post recently breaking down whether and how undocumented immigrants pay federal taxes. And you write that lots of them, in fact, do. Why is that?
So in large part, it comes down to a chance at future legalization. Many legislative attempts at immigration reform have included language about paying back taxes or good moral character, and that includes the famous Gang of Eight comprehensive immigration reform bill that was passed by the Senate in 2013. A documentation of paying your taxes for all your years working in the U.S. is a relatively easy way to show a good faith effort at being of good moral character, quote unquote.
So, but to be clear, is this about getting access to benefits? What federal benefits would these undocumented workers be eligible for?
So actually, undocumented immigrants are eligible for very few federal benefits. So SNAP, Medicaid, Social Security, they are not eligible for any of those. The one exception is the child tax credit, and that's designed to support low-income families with dependent children. However, last year's tax laws passed by Congress changed that rule a little bit, so now only filers whose dependents have Social Security numbers can claim the credit, which didn't used to be the case.
Okay. So I guess I wonder, though, how does an undocumented immigrant actually go about filing taxes? I imagine without a Social Security number, a valid one.
Undocumented immigrants use what's called an individual taxpayer identification number, or an ITIN. And an ITIN was not originally designed to be used by undocumented immigrants. And the blog that I wrote about this goes into some more detail on that if you want to check that out. But it's widely understood by experts now that the majority of ITIN users are undocumented immigrants.
So, but what happens, though, an undocumented immigrant files a tax return with an invalid Social Security number, or they apply for an ITIN? The IRS sees that. What do they do with that information? Can they refer that to DHS? How is that information being used?
Sure. So first of all you have to do to get an ITIN is file a form with your basic information, your proof of identity, but not proof of your work authorization or your status as a U.S. citizen. And then it basically just comes down to who does and doesn't and who can and can't share that information. So we actually just posted a different blog on this issue, so you should check that out for a more in-depth look. But the Social Security Administration, they do know when a false Social Security number is being used. They notify the employer, but all that employer can do is ask the employee to correct it. Any more than that might violate anti-discrimination laws. So in addition, the maximum fine, if you do get caught with a mismatched Social Security number as an employer, is a $50 fine. So the cost really isn't that high.
So there's probably not a lot of enforcement happening.
That's right.
At that cost level.
And for an ITIN, information on those who have ITINs is legally protected under privacy laws. So from an enforcement perspective, it might make sense to say, oh, well, if we know that all these people using these numbers, the majority are here illegally, we should use that information. Actually, that would require a change to immigration law. So as it stands, DHS and ICE do not have access to that info.
Thanks, Hunter.
Great. Thanks, Jordan. Let's turn now to Chris Ramon and how two states, California and Texas, are taking very different approaches to local sanctuary city laws. Hi, Chris.
How you doing?
So, Chris, in January, California became a so-called sanctuary state following the passage and enactment of Senate Bill 54. But that law, which limits what information local law enforcement can share with the federal government for immigration purposes, is now the center of controversy. The Trump administration has sued California over this. What are they saying about how this law impacts federal immigration enforcement?
Right. So Senate Bill 54, I'll just refer to as SB 54 for this segment. The federal government basically stated that this law, and there are actually two other related laws as well that address the enforcement of federal immigration laws in California. Basically, top level, they were saying that this inhibits the capacity for the federal government to enforce federal immigration laws in California. in the instance for SB 54, they're talking about issues related to whether or not state and local governments that have information on the citizenship status of individuals has to share that with the federal government. And their view, and this is the view that they've had actually on issues related to sanctuary policies, is that, if they have that information, you have to share it with the federal government for immigration enforcement purposes. But of course, the state of California is arguing that that's not the case, that they're able to implement this legislation. And as a result, you're looking at pretty much a very protracted legal battle over SB 54 and the two other laws that the state legislature passed. So it's going to be a pretty brutal fight moving forward on this issue.
So how are local governments reacting? Are we seeing any blowback at the local level?
So this is where it gets really interesting. I wrote an info brief a while back talking about how with sanctuary policies, you have 3 different levels of governance or governments that participate in these issues. You have state governments like California that can pass a pro-sanctuary city law, but then you can see counties and cities actually having their own policies on these issues. So in reality, what you're seeing is this is actually now starting to come into the fore with this debate in California, because what you're seeing a lot of cities, particularly in Orange County, either voting to exempt themselves from SB 54, or they're actually voting to, basically support the Trump administration's lawsuit against California. And so it's really interesting to see this dimension of not only a battle between the federal government and the state of California, but now California, Sacramento is not facing off against city and county governments. Basically, they're facing off against, it's 2 fronts. It's the federal government against California and the California against cities and counties in Orange County. And so it's really fascinating to be able to see how this is now starting to be able to spread through the state due to the fact that the state adopted that policy.
So on the complete other side of the spectrum is Texas. Now that state enacted a law banning sanctuary city policies. And after a court battle, that law is now taking effect. So are there parallels between the debate happening now in California and in Texas as a result of these actions?
Definitely. I think so. With Texas, the law in question is Senate Bill 4, SB 4. And the story behind that law is that Travis County, which covers the city of Austin, the sheriff enacted a sanctuary policy, and in response, the Texas legislature passed SB 4 to sort of basically ban all sanctuary cities in the state. And then what you saw is that you started seeing cities like San Antonio and Austin sue the state for SB 4. And so then they started taking this to federal court. So you actually are seeing a parallel, but you're seeing a parallel in the opposite direction. A state passes an anti-sanctuary city law, and then you start seeing cities that are largely considered blue cities in a very red state basically fighting back and trying to push against that anti-sanctuary city law. So then you're looking at California, which is a pro-sanctuary law, but you're seeing cities in, Orange County's changed a little bit in its voting patterns, but it's still purple, and some of these cities are still pretty conservative in a very blue state. So those are the interesting parallels. It's just basically what you're seeing is cities, counties intersecting themselves into a broader national debate about basically the extent to which states and local law enforcement should be coordinating and working together on the enforcement of immigration law. That's the big story, I think.
So what are the broader implications of these laws on enforcing federal immigration law?
Well, essentially, they're trying to basically delineate the extent to which a state and local governments, including county and cities, should be cooperating, coordinating with the federal government enforcing immigration laws. And I think that stepping back, this is really important because I think that this is just an open area where people are trying to find a way to balance the interests between the capacity of the federal government to be able to enforce immigration laws and the way that states, counties, and cities feel that the role that they should be playing in this effort. So really, the outcome of this battle, not only in terms of the legal battles, but also the ones between California and the cities that are criticizing SB 54, or in Texas and the cities and counties that are criticizing SB 4, I think it's going to, the way this shakes out, I think will really determine the extent to which the federal government can use local law enforcement and state enforcement to be able to enforce its immigration laws.
Great. Thanks, Chris.
Hey, pull out your phone and go to our social media pages. You can find Bipartisan Policy Center on Facebook or on Twitter at BPC_bipartisan. You can even follow along as we work in studio here in our podcast area on our Instagram account at BPC_bipartisan.
Next, let's catch up on the administration's plan to deploy National Guard troops to the U.S.-Mexico border. This all stems from a tweet from not long ago from President Trump. Teresa Cardinal Brown is here to explain what happens next. Teresa, as you wrote about in a recent blog post, it's not quite that simple because governors control the National Guard. So what's going on at this point?
So after President Trump said that he was deploying the military to the border, the Department of Defense and the Department of Homeland Security got together and, like previous administrations, decided they would work with state governors along the border to deploy National Guard troops. Now, we mentioned before, this happened under President George W. Bush. It happened under President Barack Obama. So that's the avenue they're taking. But it requires that the governors work with the federal government in determining how many National Guard troops they will allow and what those National Guard troops will do. So where do things stand? Texas, New Mexico, and Arizona, which all have Republican governors, have all said, yes, they will allow troops to be deployed to the border. Department of Defense, working with DHS, has said that these troops will not be directly enforcing immigration law. They won't be making arrests or seizures at the border. They will be doing things like monitoring surveillance, helping clear roads, maybe repairing fences, doing some back office operations, and some surveillance at the border. Many of them will not be armed. California, which has a Democratic governor, initially said that, yes, they would allow some troops to go, but not in an immigration enforcement capacity. Now, Governor Jerry Brown didn't say what the kind of capacity they would allow. The president initially said, hey, great, California's on board. But then as the conversation started getting more in depth about exactly what the California National Guard troops were going to do, there was some friction.
Yeah, so as you mentioned, some tension primarily on Twitter between the governor of California and the president. Talks have broken down. Where do things stand now? What's happening in California?
So, yes, as you mentioned, there's been some Twitter battles back and forth. The governor has said that California troops will not be enforcing immigration law. He made that a red line. President Trump said some things on Twitter that said that Jerry Brown is allowing unfettered immigration throughout the southern border. Underneath that, though, apparently talks are still going on, actually, between the Defense Department, National Guard Bureau, DHS, and the actual California National Guard. And what they've said is they're still trying to work out what kinds of activities the National Guard can do that could support other DHS missions at the border. In all of this rhetoric, it's important to understand that immigration isn't the only thing that the Border Patrol or anybody else does at the border, right? They're monitoring for drugs. They're monitoring for guns being smuggled. They're monitoring for money laundering. There's a whole list of other federal laws. So it's quite possible at the end of the day, California National Guard will be deployed to the border to help with these other missions, but not immigration.
Let's turn quickly then to another big topic in the news in the last week, a significant Supreme Court decision from the last week that could have big impacts on the government's ability to deport certain immigrants. The case was called Sessions versus DiMaia, and the decision was notable in that Trump-appointed Justice Neil Gorsuch joined the four more liberal justices in the majority. Teresa, who is DiMaia and what was at issue in this case?
So Mr. DiMaia is a Philippine national who resides in California. He's a permanent resident of the United States, and he was convicted of, under California law, of a criminal burglary charge, 2 criminal burglary charges, as a matter of fact. And the crux of this case is whether or not those California charges could be considered an aggravated felony under immigration law. Now, why that's important is that immigration law defines certain kinds of crimes as an aggravated felony. This does not necessarily directly correlate to anything in state law. And so even though it lists some kinds of things that most of us would consider aggravated felonies like murder or rape, firearms offenses, and drug trafficking, it also includes nonviolent offenses like money laundering or tax evasion, perjury, those kinds of things. So it's a very long list. But part of that list in the Immigration Act also includes by reference a portion of the criminal code that says any crime of violence, and a crime of violence is defined as something that in the ordinary course of the crime could use violence. So it's a very sort of vague
Not even
definition.
that it did, it's just that it could.
That it could. It could reasonably be assumed. And so that was the section that the Supreme Court looked at. Whether or not that provision is actually so vague as to be unconstitutional.
And the decision said?
The decision said it was. It was too vague. that it didn't allow judges to determine at all with any certainty whether any of these state-based crimes could be considered aggravated felonies under the immigration law, whether it was a crime of violence. It required basically too much guesswork on the part of the courts to interpret it, and therefore it was unconstitutionally vague and violated the due process clause of the Constitution.
So if the court found that language is too vague, what impacts does that have on the federal government's ability to enforce immigration law, and what changes as a result of this decision?
Well, they basically rendered that portion of the law void. And what that means is that the government can't deport people under the aggravated felony provisions using that particular section of the law. So it either has to be listed as one of the actual aggravated felony crimes under the Immigration Act or one of the other provisions in the law. This is important because if you are designated an aggravated felon under the Immigration Nationality Act, there are specific and very severe consequences that attach to that for immigration law. For example, you're ineligible to apply for asylum. You can't apply for other forms of relief from removal. You have to be detained mandatorily and ineligible in most cases for bond. You have a permanent inadmissibility from ever coming back to the United States after you're deported. And most importantly, you can be deported without going to see an immigration judge. You can be deported administratively. So there's lots of other consequences to being labeled an aggravated felon for purposes of immigration law. So by striking down this provision, it limits the ability of the government to deport people under these expedited circumstances by using that section.
How does this decision, though, fit into the broader context? We're having a national debate over immigration enforcement and how stringent it should be, and at the same time, a conversation about whether immigrants commit more or fewer or the same number of crimes as native-born Americans.
So the Trump administration has made a very big priority on deporting what it considers criminal immigrants. And they immediately came out and denounced this decision, but said basically they're going to immediately turn to Congress to try to close, quote unquote, this loophole. Anything that they believe limits their ability to very quickly deport immigrants accused of crimes, they are labeling a loophole. It's unclear how or when Congress might try to address this, but until they do, it does mean that this administration cannot use this particular section of law to deport immigrants. You also mentioned earlier Judge Gorsuch sided with the majority in this. That was a little bit of a surprise, but not necessarily. He wrote a separate concurring opinion to the majority in which he laid out his reasons, and basically they had nothing to do with the immigration law, enforcement of immigration law, and everything to do with his belief in strict original construction of the Constitution and how court should rule when it seems that any legislation, whether it's criminal or civil action, is unconstitutionally vague. So if you're an immigration advocate, I wouldn't necessarily hang your hat and say, oh, Judge Gorsuch is on our side on this. In this particular case, he was, but I bet you in future cases, he's going to be more of a swing vote.
Fair enough. Thanks, Teresa. And that's our show for this week. Thanks for listening, and a special thanks on her last episode to our producer, Gretchen Akins. She's moving on to big things, and we wish her all the best.
Thanks, Gretchen.
Please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe to this podcast as well as all of BPC's podcasts on Apple Podcasts, Google Play, or wherever you get your podcasts. Just search Bipartisan Policy Center. Join us again next time.